We have 2 camera crews here. I can't guarantee that we will increase the number of camera crews for each lecture. So there will be some movement when the camera crews around. Please just sort of, we'll all just try to proceed as if we were not being filmed, so it captures live action. As you know, the Institute for the Study of the Judiciary, Politics, and Media at Syracuse University is organizing a semester-long lecture series on law, politics, and media. This semester-long lecture series is associated with a course that is taught at law school in Newhouse entitled Law, Politics, and Media. The aim of both the lecture series and the course is to bring in a series of prominent practitioners who can reflect on issues at the intersection of law, politics, and media from the perspective of their own professional experience. Today, we are fortunate to have Judge Joanne Alper, who will be speaking to us on the topic of methods of judicial selection. Judge Alper has served on the Circuit Court for the 17th Circuit of Virginia since June 1998. Prior to serving on the Circuit Court, she served as a judge of the Juvenile and Domestic Relations District Court for the 17th Judicial Circuit, as well as Chief Judge of that court. Before being elevated to the bench, she was in private practice in Arlington, Virginia. Judge Alper earned her BA degree, magna cum laude, from Syracuse University. She received her JD with honors from George Washington University Law School. Her professional service is extensive and includes serving as president of the Arlington County Bar Association, president of District 4 of the National Association of Women Judges, president of the Virginia chapter, of the American Academy of Matrimonial Lawyers, chair of the Family Law Section of the Virginia State Bar Association. Judge Alper is also past president of Syracuse University National Alumni Association. She is currently serving as a member of the Board of Advisors of Syracuse University College of Law and a member of Syracuse University Board of Trustees. She's a member of the Virginia Criminal Sentence Commission, a member of the Virginia Model Jury Instructions Committee, and a member of the Education Committee of the Virginia Judicial Conference. Now you may think she has no time left to do anything else, but one of the most important things that Judge Alper has done is have the original idea for an institute devoted to the study of judiciary, politics, and the media. In early 2005, Judge Alper, who had long experience, as you can gather from this resume, being a judge, practicing attorney, and prominent in the governance of judicial affairs, had begun to see the growing intersection and interaction between law, politics, and the media, and had also noticed that there were no nonpartisan research institutes devoted to the study of issues in this area. In conversation with Chancellor Nancy Cantor and Dean of Syracuse University College of Law, Hannah Arterian, Judge Alper brought up the idea of creation of such an institute. Well, one thing led to another, and next thing you know, here we are, inviting Judge Alper back to give a lecture in a series run by the Institute, which she really, in most important ways, founded. So we are here for Judge Alper. I guess we're here to hear her lecture, and we're here because of her at the same time. So please join me in welcoming the Honorable Joanne F. Alper.
Thank you, Keith, for that very generous introduction. And looking out at you today, you certainly heard from Keith my involvement with the creation of the Institute for Judiciary, Politics, and Media. It is like I'm looking upon you as though you are my children. I'm not paying your tuition, but it really does feel that this has come so far from an idea in my head that was born out of basically outrage over the Terry Schreiber case. That's where it all started back in early 2005, where there was so much going on about the state court judge and what could happen and what was the right decision in that case, and the Congress going ahead and passing legislation that tried to take the case out of the state courts and then not only put it in the federal court but almost tell the federal judge what to do with it. I just said, something's wrong here, and there's no one out there, and all the coverage that was going on and all the 24/7 news media, there was nothing that was really saying, that was able to talk either from the judge's point of view or just from a neutral, an academic point of view. Everybody that would be interviewed by any of the media or the press was talking from either somebody siding with the parents or someone siding with the husband. The judge, and we'll talk about this later, but the judge can't ethically talk about the case or discuss the case. And this was crying out for some nonpartisan, some academic program that could be out there and train future members of the public and also educate the public. And that's where my idea came from. Talk to the dean, talk to Chancellor Cantor. And one of the things that you all should know and be very proud about, and I certainly am as an alum of this university, is that this went from an idea in my head after at a conference with Dean Arturian in early March of 2005 to a full-blown 2-day symposium, the Bench Press Symposium, that was the inspiration for this book that you used, in October of 2005. And what I learned about academia is nothing in academia happens that fast. And it happened that fast because of the support of the Chancellor and the deans of the 3 schools. And most importantly, it happened because the deans of the 3 schools had the extraordinary brilliance to appoint Keith Bybee, Lisa Dolak, and Mark Abbey to be the 3 people who put it all together. And that was the real brilliance of that. And you were very fortunate to be working with the 3 of them, and I'm delighted, absolutely delighted to be here today. And there's no way you all could have kept me away, even if there wasn't a UConn basketball game tonight. I want to tell you a little bit so you understand where I'm coming from. And if you've read, and I'm not asking anybody any questions, there were no pop questions. I'm not using the Socratic method. I did that enough in law school myself. But if you know a little bit about me from my essay in the book, you know that I did my undergraduate work here at SU. I went to law school at GW. And when I was a second-year law student, I got a job as a law clerk with a firm in Northern Virginia, in Arlington, Virginia, that hired me as a law clerk, and then I stayed on there after I got out of law school, I passed the bar. I stayed on as an associate and became a partner a few years later. Stayed there until I went on the bench in 1991. And I started out as a judge in the Juvenile and Domestic Relations Court in Virginia and served in that court from 91 until 98. In 1998, I was elected a judge of the Circuit Court in Arlington County. And the Circuit Court is the court of general trial jurisdiction. So we do everything from capital murder to contracts cases, personal injury cases, divorces, world contests, you name it. We see everything. We even hear the appeals of the traffic cases from the lower courts and landlord and tenant. So we see a wide range of matters, and we are, as I said, the highest level of trial court. Lots of jury trials. And what you know from the book is that judges in Virginia are selected in a unique way. We're the only one of the 50 states that is selected by legislative election. That means that we don't have to go out and shake hands, but we actually get selected by both houses of the General Assembly. And that's going to factor large in what I talk about with you today. And I'm going to try not to overly lecture you, but to leave plenty of time for questions and answers, because this is such a, the methods of judicial selection are so different around and across the 50 states, and then obviously the federal judiciary is running. I'll touch on that as well. But when judges get together, lawyers get together and tell lawyer jokes, and judges get together, they often talk about judges in other states. And one discussion that's usually had that often rings true is about the judge in Texas. The state court judge in Texas is about ready to start a big trial. And the first day of trial, the plaintiff's attorney walks up to the judge and hands him a big fat envelope. The judge takes it, counts out the money, $5,000, puts the envelope in the drawer. The next day, the defense lawyer walks up, hands him another wad of money, and he counts it up, and it's $10,000. Judge takes $5,000 of that out, hands it back to the defense lawyer, and says, "We're going to try this one on the merits." That's the problem with judicial selection. That's the issue that I'm going to talk about today, is the issue of money, politics, and judicial selection. What's clear is that there's got to be a basis for judicial authority. Of the 3 branches of government, the judiciary is clearly the weakest. We have no money. We're dependent on the legislature to fund us. You may recall that during the Terry Schiavo case, there was some discussion that when the Congress was unhappy with some of the rulings and some of the things that were going on in the federal judiciary, they were talking about not funding. Well, we're just not going to give them any money. We won't pay the judges. It didn't happen, but that was certainly raised in a threat. We also cannot enforce our orders. If I order someone evicted, I can't do it. We have no personnel ourselves that can go out and do that. We're dependent on the executive branch to carry out our orders. So of all three branches, judiciary is clearly the weakest. And so the issue is, how does the judiciary have any standing? How does it have any power? How does it command any respect? Well, it only commands the respect that it can from the members of the public. Because you're sitting in front of me as a judge, and I tell you that to do something or not to do something, and you do it. I give custody of a child, and I tell the one parent you can visit on a certain number of days, and they follow the orders. And what my clear theory is that the method of selecting judges impacts on the public's perception of judges. And that governs how the public looks at their judges and how willing they are to accept the decisions of the judges. And that impacts on both judges individually and the judiciary as a branch of the government. Think about it. And you're all obviously from different states and different parts of the country. You know, when you're driving around in October, November, do you want to see your judge sitting on the billboard with a gavel in his or her hand, or handing out flyers at a stadium before a sporting event, or attacking another candidate for judiciary on TV ads, or posing in those cute things with puppies and small children? Or worse, do you want to see your judicial candidate or your judge telling you how he or she's going to rule on a case? Well, I'm going to put every drunk driver in jail. I don't care. You know, whatever the evidence is, I'm going to find every drunk driver guilty and put him in jail. Or taking positions on issues that are going to come before them. Well, if someone comes before me with a parental consent on an abortion, I am or I'm not going to grant it. That's one of the issues that faces judges who are running for election. Worse, do you want to see your judge defending him or herself after granting a motion to suppress? And I don't know how many of you are law students, but a judge gets a critical issue on a constitutional violation by a police officer, and in a very hotly contested and highly publicized case, the law tells that judge they have to grant a motion to suppress. The public doesn't want that motion granted. They don't want that guy out of jail. But then, do you want the judge having to face that kind of a quandary? The question is, what has to be done to ensure the proper public regard for the judiciary? And I believe that starts with how the judges are selected. If you've read the readings, you see that Justice C. From Alabama and Justice Graves from Mississippi both were elected by popular election, and both of them think that's absolutely the best way to pick judges. And I was elected by a legislative election, and I think that's the best way. And Judge Walker talked about the federal court process, which is yet different because you got the presidential appointment with the Senate confirmation. And all of those, though, the theory and the line that goes through every one of those essays is that the criteria for the best system of judicial selection has to be that which would ensure the independence of the judiciary, the legitimacy of the judiciary, and the quality of the people that you're putting on the bench. And then, so what does that lead to? How do we decide from reading all those essays and reading and thinking about it, what's the best method for selecting judges? Is there a method that eliminates politics? Is there a method that allows for dignified and substantial debate rather than acrimony and speaking in 10-second sound bites? Is there a method that avoids the money, avoids campaign contributions and all the issues that raises, and ultimately results in a highly qualified and competent judiciary in which the public has confidence? Now, I'd ask you, do any of you know, do you know how many, I want to know if you know how state judges are selected in your home state. How many of you have judges who are elected by popular, nonpartisan elections, if you know? How about by popular partisan elections, where the judges run as Democrats or Republicans? Okay. Appointment, a gubernatorial appointment, and then they run in retention elections. Legislative elections, obviously, unless you're from Virginia. So, and a lot just have no idea. You've never focused on it, right? Which is okay. I mean, if you haven't focused on it, you're like most of the public. And like many lawyers and law students, I know I didn't focus on it until I actually decided I wanted to be a judge, I think. But one of the things, have any of you been involved in judicial campaigns where you either supported a judge or worked for a judge, or you've done that at California?
Yeah.
And what you'd see from reading the essays and from talking to judges around the country is that Most judges like the method that got them there. I think my method is great. I think it's the best. It's the least, the most dignified, the least partisan. Justice C and Justice Graves are obviously equally as emphatic that they believe that their methods are the best way. And I think that that's the problem. You know, if it worked for you, it's good. I will tell, and I'll talk to you more about it later, but I was a candidate for a federal judgeship earlier this year. And although I got the support of the local senators from Virginia, I did not, ultimately, I wasn't the selection of the White House. But, you know, I really like the Virginia method because I've succeeded there, and I'm not so crazy about the federal method now. So I think you really see it's really based upon how you've done in that method. But one thing that struck me about my first experience with popular election of judges occurred in 1995 on the steps of the Carrier Building right next door. I was up here my son's freshman year, and it was October, and it was Parents' Weekend. Beautiful, beautiful, sparkling Saturday afternoon when the football team was really good. And I walk up the steps, and a gentleman stops me and hands me a comb and says, "Hi, I'm so-and-so. I'm running for family court." And at that point, I was a juvenile court judge, which is probably similar to what family court is in New York. And I looked at him and I said, I gave him back the comb. I didn't want him to waste his comb on me. And I said, "Thank you, but I don't go here." And I looked at my husband and I said, if that's what I had to do, I couldn't do it. I couldn't go out there and stand there and run the popular election. And frankly, one of the issues that I think is worth thinking about is, does that kind of a system of election, and I think Justice C mentioned this, and I think also Alan Target, does that cut down on the number of people who might run? Would somebody who might otherwise be a really good judge decide, I don't want to go through that mess, I'm not great at standing there and glad-handing and shooting the breeze and making small talk and the like, and asking people for money? And so therefore, you take someone who might otherwise have been an excellent judge, might have done a phenomenal job as a jurist, but who never even thinks about it because the method of selection has put him or her off. And that's something that has to be considered when you're thinking about judicial selection. Now, I want to look a little more in depth about the various methods and talk about some of the things that we've seen and discussed in the essays. And I really, Justice C, I really was impressed with Justice C's article. I didn't agree with it, but I was impressed with the arguments that he made of why popular election is the best method of electing judges. He goes back and looks at history, talks about the Founding Fathers and the initial distrust of the people and the evolution into Jacksonian Democracy, which is when most of the states that went with and started judicial elections or popular elections occurred during the era of Jacksonian Democracy. My research indicated it was not easy to find that Virginia, for a short period in there, did go to popular elections, and they quickly, some would say because it's somewhat of an elitist state back then and even now, said, no, we're going to go back to doing it the way we've done it before. But there was a brief period that Virginia did have popular elections. But the judges were not, the idea in Jacksonian Democracy was that judges did not have to be indebted to the legislature or to the executive. They weren't dependent on either of those for their jobs. They were dependent solely from the will and the power of the people. And in theory, this is a wonderful idea. I think that to have a truly independent judiciary that doesn't have to ask the executive and ask the I mean, they still need to get money and others, but obviously if you've got your own independent power base, you don't have to worry. If I go to the governor of Virginia and say, we need more money up in Arlington for whatever it is, the governor will look at me and say, okay, yeah, thank you. Anything else you want to tell me? Goodbye. And it doesn't matter which governor went where. If I had a power base of individuals who had elected me and I had won by 90% vote in Arlington, and then I go to the governor and say, here's what we need in Arlington, I have a feeling that I get listened to a whole lot more because I had a power base. And that's something that I think that Justice C makes the point very powerfully in his essay, that is something that that helps to ensure the independence of the judiciary. However, and to me this is the big however, is how does that public decide who should be the judge? And obviously we're not looking back at Jacksonian time, we're looking at our current time. We look at ads, we look at 30-second spots on radio, we look at TV ads, brochures, billboards, ignorance, bias. Oh, I'm not going to vote for that person because they have a foreign-sounding name, or I'm going to vote for, I'm going to vote for all the white males on the ticket. I don't know. That's oftentimes how people vote. You recall that there was a California election several years ago, and I spoke about this at lunch. I wrote about it in Bench Press because I found it. It happened right on time we were writing this, where a woman had been a probate court judge in LA for almost 20 years and had done a great job, no problem. And a young lawyer who had practiced for a few years, but with her most recent job was running a bagel shop, I think it was in Manhattan Beach, decided she wanted to run for judgeship. And she picked the judge to challenge. She picked this particular judge because the judge had a foreign-sounding name. I don't know if she was Eastern European, and she had an Eastern European-sounding name. And therefore, she said, well, I think this would be the easiest person to beat. And she did. In the popular election, she beat the judge for no reason other than the fact that one name was Jane Smith and one was something that sounded like it was foreign-sounding. Now, to me, that is a story that says, in a nutshell, the problems and the dangers with popular election of judges. And that's true whether it's a partisan or a nonpartisan election, whether that judge had run with an R or a D next to her name, she was running for that particular reason. And so that's a true issue because how do you educate the public? We have the media folks, and I'll look at Mark and others, and there's lots of trade magazines. We talk about the American Lawyer and others that talk about judges, that complain about judges who do bad things, who write about judges who do good things, but the public doesn't read them. The public doesn't necessarily listen, and you don't see when you're watching on CNN and MSNBC and Fox, you're not seeing a lot of discussion about a local judicial race. Or you'll see discussions, not even in federal appellate courts. You're looking only at the Supreme Court when they really start talking about judicial wins. You're not seeing it covered on the local news. I know where Maryland has, and West Virginia have contested judicial elections that are within our media market in Northern Virginia, and we don't see any local coverage. The local, NBC or ABC or CBS stations aren't looking at it. So how do people get this information? If it's a partisan election, I guess they vote. If they're Republican, they vote Republican. If it's Democrat, they vote Democrat. Otherwise, they're not getting a whole lot of information. Or they're voting for the person who says, I'm going to be toughest on crime. Or I'm going to let you all out of your traffic tickets. Whatever the issue du jour may be of that community. But that's not an educated electorate. I dare say everyone here would agree that if that's the information we're basing our decision on who we vote for president, that would be a rather ignorant basis. Well, you should have no less information about your judicial candidates than you do about who the president is, because that judge and that judge's rulings can affect you, your family, your property, just as much as the president in some ways more. So the next method, that's why I think there are some real issues that people need to think about in terms of popular elections. Another method, appointment with retention elections. Now, obviously, that gives a little more of a screening process, which you have an executive, the governor, appointing someone, and then the person runs in a retention election. The appointing can be good or bad. I mean, if you have a governor who really works hard and appoints people who they've gone through a screening process and panels and all this other qualification bases, it can be great. You also have governors, and it's been well documented, who appoint their pals, their cronies. This is the way it's always been done, and this is the guy I practice law with, and so what if he falls asleep on the bench? It really doesn't matter. He's my buddy. And then you have that person running for a retention election, and the statistics are that judges who run a retention election are reelected 99.whatever%, regardless of how they do or what they do on the bench, because people just aren't educated about what they do on the bench. And that's another issue. So again, it comes down to how do you inform the electorate? How do you have the electorate make an informed decision? Then I come to the method that I think is most superior, and that's the legislative election. And Virginia is the only state that does this. And it's a process, and it's not perfect. I'm not sitting here saying it is. But it's a process, but it starts with a bar and citizens screening the judges for the judicial candidates. Then it goes to the members of the local delegation, both the House of Delegates and the Senate, for their screening, and then ultimately the person that the local delegates and senators select goes to the House and Senate Courts of Justice committees for their interviews, and then ultimately they're elected by both houses. Now, it's clearly political. The members of the General Assembly are politicians. When the General Assembly was controlled by the Democrats up until the late 90s. Everybody elected could at least withstand, they weren't all active Democrats, but they at least could be elected by Democrats without too much concern. After the Republicans took control in the late 90s, the judges who were newly elected were generally ones who had been akin to the Republican Party. And it didn't, except in areas like in Arlington where there just aren't any Republicans. There are no elected Republicans anywhere in Arlington County. So, but it didn't become a partisan dogfight. If a local delegation wanted you, whatever your political background had been, or no political background as I had, you were all right. What's going to be interesting this year is we have a new phenomenon. The House of Delegates has remained in Republican hands. The Senate turned to the Democrats in the last election by one vote. They have a one vote majority. So there's a whole bunch of judges who appointments are sitting there, and no one quite knows what's going to happen with them. So I'm not saying it's not a political process, but at least it's a political process that is being accomplished by individuals who have a little more knowledge. When it comes to election of the judges, they've looked at things judges have written. They listen to other lawyers about the kind of work the candidates done in the courtroom. In re-election, because in Virginia we have to be re-elected every 6 or 8 years, depending on the court that you're on, they look at the opinions you've written, they look at the cases you've handled, they check to see whether or not you've had any disciplinary actions before what we have is called the Judicial Inquiry and Review Commission, and the acronym for that is JIRC, and it's fondly referred to that by most judges in Virginia. But they do some looking. There's a judge right now who is a good friend of mine who sits down in the Tidewater area of Virginia, and he was a prosecutor before he was a judge, but he got reversed in a very widely circulated opinion by the Supreme Court based upon something he did to another lawyer in terms of accusing or dropping it from the court appointment that really raised questions about whether he was really an impartial, whether he was still too much of a prosecutor as a judge. And so he's having some re-election difficulties. He may not get re-elected. But the decisions being made on the merits, the legislators are listening both to his detractors and his supporters, and will make an informed decision on that. So clearly, to my way of thinking, and again, this is the way I was selected, so I do think it's best. But I think that does take a lot of the uncertainty and a lot of the ignorance out of the selection process. But it does mean that perhaps the judiciary is a little less independent, because clearly you're beholden to the legislature for your selection. And there have been times over the years when people have suggested that a judge made, in the old days when the legislature was dominated by lawyers, I think it was a little more difficult than it is now. Now most of the General Assembly is non-lawyers. But in those days it would be, well, you've got a judge on the bench, and you've got the member of the General Assembly who put that judge on the bench, and they're in front of you wanting to argue a motion or to get a continuance of a trial date or whatever, and there were criticisms made that was a judge being unduly favoring that particular legislator. I don't think there were any documented cases that happened, but it certainly puts the judge, that would definitely put the judge in an awkward position. I think I've been lucky over the years. I think I've only once or twice had members of the General Assembly in front of me, and it was usually for something that was non-controversial, like you're allowed to continue a trial if you're a legislator. It's in the Constitution that you can't be made to come to trial within 30 days before and after the General Assembly session. So things like that are non-controversial, and you do them, but it could put you in an awkward position. I would admit that it does give you more of a tie of the legislature. But they don't ask you questions about politics. They didn't ask me when I went for, how I felt about any of the hot-button social issues of the day. They didn't ask me who I voted for. They didn't ask me if I'd given money to Republicans or Democrats. Or there were no inappropriate questions about my rulings or about any of my thoughts on anything. And I think that's appropriate. They wanted to know what my temperament was. What was my demeanor in court? Did I treat people fairly? Did I treat them with respect? Did I know the law? Those are the kinds of things you want. Those are the kinds of things you want the members of the public to be asking if they're voting for you. But these are the things that at least were asked in my experience. I think that's what we should be looking for. And when something inappropriate occurs, what I found is, in our situation, the legislature deals with it. There was as I said, the legislature was recently turned over to being a lot of non-lawyers. And a situation arose a few years ago where a brand new legislator from the Tidewater area decided he didn't like the way his friend's case was being handled by a judge in that particular court. And so he just picked up the phone and called the judge. And the judge took the call, not knowing what he's calling about. You know, Senator so-and-so calls you, please pick up and say hello. And he started talking about the case, and the judge immediately, the hairs on the back of this good friend of mine, of his neck started to stand up. You know, this case is actually ongoing, and here's the senator telling you that he doesn't like the way you're ruling in this particular case. And the judge, you know, basically said, I can't have this discussion with you, it's inappropriate, hung up the phone, made a phone call to the head of the delegation, and ultimately the legislator was sanctioned by the Speaker of the House. But at the same time, it's something that really, you know, that if you don't know, you know, this member of the General Assembly just felt, well, you know, this is a guy I did something for, I gave him his job, I can call him up and tell him I want something, which in 99% of the things, the patronage jobs they give, there's no problem with. But in this 1%, there's a problem. But it was dealt with. Again, it was dealt with. It wasn't under the rugs. It wasn't anything that caused any problem. In addition, what we have now in Virginia is a judicial performance evaluation process, which means that in addition to all the other information the legislature has when they reappoint you, they're going to have evaluations. And these evaluations get input from lawyers, from litigants, from jurors if you're on a circuit court where you have juries, from clerks, and they basically want to know, you know, are you fair? Do you demonstrate bias to, you know, plaintiffs, defendants, prosecutors, criminal defendants, fathers, mothers in custody cases? You know, do you treat people rudely? Do you have any bias, racial or ethnic or gender bias, things of that nature? And you start court on time. I mean, they're not, you know, they don't go into the substance of your ruling, but they go into the things that are important in terms of the judiciary, them looking at your reelection is, you know, are you handling yourself and treating the public? Are you a public servant? Are you doing what you should be doing? And that's another tool that's just been implemented in the last several years that our General Assembly is going to have when they look at judges for re-election. And it's a great tool. It certainly, I think it helps the judges, because if you're a good judge and you score well on those, it's going to help you and protect you. And if you're a bad judge, you shouldn't be there. But in all of this, what all I've talked about, there's one thing missing that is clear and ever present in the other parts, in the other methods of judicial selection, and that is money. There's no consideration of money. I don't have to go out there and raise any campaign contributions. I don't have to, there's no issue that I'm going to favor one side or another because they contributed to my campaign. Yeah. Mark contributed to my campaign, Keith didn't. You know, am I going to favor one side? Am I going to favor Mark because he gave me the big bucks? And that leads to what I firmly believe is the most important issue in deciding the proper methods of judicial selection. The real problem, in my opinion, with popular judicial elections is not politics, because politics is ever present. Politics is there whether it's a federal appointment by the president. You know, when a Republican president is in office, the active Democrats generally don't apply for federal judges, just like the other way around when there's a Democratic president. It's really not even the lack of informed public information to the public regarding the qualifications of the candidates. That's really not the issue. I think the media could and should, for those of you who are Newhouse students, do a better job to inform the public about judicial candidates. And I would love to, maybe during the questions and answer later, hear from some of the Newhouse students and some of the law students and others about what can the media do, because we get so much of our information nowadays from the mass media. You know, not only from the mass media of my generation, TV and radio, but internet and blogs and things that are much more popular with the under 30 generation. But the real problem is money. The money involved in judicial elections and how it affects both the perception and the reality of judicial decisions. It's not. It deals with both of those. Justice C said, and I wrote this down, it's on page 87 of this article, I have personally seen no evidence that campaign contributions affect how a judge votes, though, of course, campaign contributions are no doubt made to candidates whom the contributor believes share the contributor's judicial philosophy, end quote. Despite Justice C's beliefs. There is a body of data that's beginning to be collected that tends to show just the opposite, that contributions do affect judicial decision-making. Timely and interestingly enough, an article was published in the New York Times just last week called Looking Into a Campaign Cash on Elected Judges. It was written by Adam Liptak, who writes about the judiciary and law for the Times. And in fact, it's a follow-up on a much longer article that he did in October of 2006. And there, he basically looks at an article that's being published in the Tulane Law Review. It's a study that was done by a law professor in Tulane of the judges on the justices of the Louisiana Supreme Court. And when I read this article, I did when trying to find the law review article, I called Bert. Bert Kaufman was the first graduate assistant. He was the moderator of bench press. He is from Louisiana. He graduated from law school last May, and he is currently clerking for a judge in the northern part of Louisiana. And I said, Bert, can you give me a copy of this law review article? I'm going and speaking at the Law, Politics, and the Media class next week, and he apparently did what he could, but it's not out and published yet, and he couldn't get me a copy. I don't know how the New York Times did, but if Bert can't get it, it can't be gotten. So I have to rely upon what's written in the article. But the law professor at Tulane couldn't understand how the justices of the Louisiana Supreme Court could regularly hear cases involving people who had given them campaign contributions. He thought that just seemed to be a raw conflict of interest. And so what he looked at, and he studied it with an economics professor at Loyola in New Orleans, and he said that the thesis there was initially, judges don't change their votes in response to contribution. That's what he said, the argument, just like Justice C said. Rather, contributors support judges whose legal philosophies they find congenial, and incidentally sometimes benefit when those judges apply the philosophy in a way that helps them, in a principle, consistent manner that just happens to help them. But what happened was, Professor Palmer, in doing this research, looked further. He did a baseline and looked at cases in which no one in the lawsuit had ever made a contribution, to sort of see how the justices voted when there was no money involved at all. And then he said some of them he found tended to vote for plaintiffs, some of them tended to vote for defendants. He mentioned one particular justice who was slightly pro-defendant in cases where neither side had given him contributions. And he voted for plaintiffs 47% of the time and defendants 53% of the time. But in cases where he received money from the defense side, or more money from the defense when both sides gave money, he voted for the plaintiffs only 25% of the time, 25 down from 47. In cases where the money from the plaintiff side dominated, he voted for plaintiffs 90% of the time. That, as the article points out, that's quite a swing. Larger contributions have larger effects, and the greater the size of the contribution, according to the professor, the greater the odds of favorable outcomes. The same general conclusions were reached in this article from 2006 that did the same kind of study of the Supreme Court of Ohio, comparing the way the justices there voted in connection with the contributions that were made to those justices. And it seems to me that that is really the glaring issue here. Would these judges have ruled differently if no one had made those contributions? Would the plaintiff have won more? Would the defense have won more? We don't know. And perhaps they would have ruled exactly the same. But think of it if you're the litigant. Think of it if you're a member of the public looking at that court and trying to decide whether you should give respect to the decisions of that court. Wondering if you're the litigant, you sued a major company, some kind of a tort case, and you won a big verdict at the trial court, and that verdict was taken away from you by the appellate court with a well-reasoned, based-in-law decision. But you find out that the majority of the judges on the Supreme Court have been given large campaign contributions by the defendant in that case. Does that make you wonder about whether you had a fair shake? Does that make you wonder about whether everybody walks into the courtroom with the same rights? Does it make you trust the judiciary? My problem is that even if, and my thesis is that even if the contributions do not affect that judge's decision. And that judge would have ruled that way, exactly the same way, regardless of contributions. The appearance of impropriety is enough. Judicial canons all over the country, and we all have canons of ethics that we have to follow. And one of them is consistent, whether you're in Virginia, or in Maine, or in California, or Alaska, is a judge should avoid the appearance of impropriety. If your child goes to a private school and that private school gets sued, you shouldn't take that case. Even if you really have no interest in what happens, it doesn't look right. And that's the kind of appearance, to me, the appearance of impropriety that money does, without necessarily saying if it does have any real effects, but the appearance is enough to, I think, diminish the stature of the judiciary and diminish the respect that the members of the public have and have to have for the judiciary to remain strong and independent. And that's the real issue. That's the real issue I think we need to talk about, is not whether judges vote a certain way because they agree with their contributors, but because they vote that way because their contributors affect them, and even if they don't, they vote that way because of their philosophy, but the public believes it's because of contributions. And the article that I read from Time was pointed out that there was a challenge that you may recall to the way New York State elects its judges. There's a whole problem going on. I think it's mostly, from what I've been reading in the Times, mostly based upon what happens in the New York cases and selecting judges in the New York City area, and they're sort of selected by party caucuses and this sort of thing. The Supreme Court didn't hear that case, or said the Constitution doesn't impact on it. However, what's quoted here is that several justices went out of their way to question the practice of electing judges. Justice Anthony Kennedy and Stephen Breyer said, for instance, that campaign fundraising and judicial elections might be at odds with the perception and the reality of judicial independence and judicial elections. And that's something to really think about. What are we doing here? What are we doing for the future? There's no perfect method of judicial selection, except, I guess, if you had judges who were anointed by God, which many judges, mostly federal judges, think they are because they get lifetime appointments. But all methods involve politics. Federal, you have to, you've got to get the support of your local the senators from your state, then you've got to get the presidential approval, and although that tends to be, looks at merit a lot, there's an awful lot of politics, as I found out, that goes into that. Partisan election, clearly you're running as Republican or Democrat with whatever baggage that brings to your locality. Non-partisan election, you're running and without a party label, the electorate knows even less about you. Gubernatorial appointment, retention election. You've got the politics of whoever the governor is, and then the running for re-election, and even legislative election, as I've talked before. They all have politics. You can't remove politics from judicial selection unless we're all going to be appointed. There's even, appointed from some higher method. But the money is the issue, and we need to talk about the amount of money. We've looked lately at some of the amounts of money, especially in connection with campaigns for state Supreme Courts. The amounts of money are ungodly. I think one of our participants in bench press, who had been the Chief Justice of the West Virginia Supreme Court, and was targeted for, this is Justice McGraw, was targeted for defeat because he had ruled in favor of some plaintiffs against a large coal company. West Virginia is very much coal country. And a coal company executive based in Richmond, Virginia, not even the same state, financed a huge groundswell, and there were ads running about this man. I mean, the most horrible things. And he had so much money that West Virginia usually doesn't come into the Washington, D.C. market, but we were seeing ads against this, in Northern Virginia and Washington, D.C. That's an expensive media market to run ads. But they did, and they got him defeated. And now, what's an interesting footnote of that is that the new justice is now under fire because people are now complaining about his ties with the Richmond coal executives. So there's some sort of internal investigation going on there that I just read about. But the money for judicial elections doesn't necessarily come from people, like you sitting out there saying, I'm going online, I'm going to give money to Barack Obama or Hillary Clinton or John McCain or Mitt Romney or someone. Usually the money that comes into a judicial election is from people interested in the judicial system. It's from lawyers. It's from businesses. It's from interest groups. So they already have an agenda and a reason to have that money have influence. And if that doesn't create a real conflict of interest, it, as I said, creates an appearance of conflict, an appearance of impropriety. And that leads to the lack of confidence in the judiciary and its decisions. And are you getting something? Is this decision being made because it's the right decision as a matter of law? Or is somebody getting paid back for supporting a particular judge? The lack of confidence in judicial decisions that brings up, I think it totally diminishes the stature and effectiveness of the judiciary as a very branch of government. Now, I think a lot can be done, by lawyers, by politicians and public officials, and by the media. I'm going to jump on the media first. The media needs to give greater information about judges, greater coverage of legal issues, locally and nationally. And of course, I know it's not as sexy as Paris Hilton or Britney Spears, but they need to focus at the local level and learn about the court system. Years ago, I had occasion to get to know Nina Totenberg. I was president of the National Association of Women Judges in the local D.C., Maryland, Virginia. And she came as a speaker to us. And one of the things, she told us how she started out covering local courts and stuff. And she's not a lawyer. And here she is, she's covering the Supreme Court and one of the most authoritative individuals about Supreme Court decisions. But she said what local news outlets generally do, they send the brand new, right out of school reporter to go cover the courts. And that reporter knows nothing, doesn't know about the judicial system. It grates on me when I hear somebody on TV or radio saying, so-and-so pleaded innocent. No, you don't plead innocent, you plead not guilty, but you don't plead innocent. But they don't even know the terminology right. So what Nina advised the group of judges to do at the time, they said, invite in the local reporters who cover your courts. Have them come in off the record, we can't talk to them about cases, but tell them about how the court works. Tell them about your scheduling. Tell them about how your different motions and things work so they understand it. So I tried it. Nobody showed up. I mean, I'm in a big media market. I didn't think anyone from the Washington Post was going to show up, but I thought, well, the local Northern Virginia Sun or the Arlington Gazette or somebody, and if we send out an invitation saying, come so we can talk to you about the court. So, you make the effort to do that, and when the media doesn't respond, it gets a little frustrating. That's why there's a lot of distrust between the judiciary and the media. What we need, for those of you who are going to be in the next generation of media, this is really important. I've often thought that it'd be great to have people who were lawyers, people who are media, who are covering the courts or anything to do with the judiciary, to be lawyers, to have a law degree, at least to have some legal background so they understood what was going on. It's the media's job, more so nowadays than ever before, with the public so reliant upon the media, to educate and inform the public. And if they're not giving them the whole story or not giving them any story, you're taking away one large basis. I don't expect members of the public to go look at the website of a particular judge to see where he or she stands on whatever the issues are in their community. It's got to be up to the media to cover that. And to cover the courts, to be in the courtroom. What I found interesting, I don't mean to be dumping on the media, it doesn't make Mark. I'm not being... When so many courts have cameras in the courtroom now, and we have it on a very limited basis in Virginia. And every time I get a request from media to come and cover a trial, it was never sort of what happens in the courtroom every day, what real life people go through. It's always some, the Marv Albert case was in our court 10 years ago. And my colleague who had the case didn't allow them in. But that's the kind of stuff they want to cover. They don't want to necessarily see someone else who might have been charged with the same crime. Or just to see how the system works. The people our public gets to see how the system works when they get summoned for jury duty. And it's amazing when I talk to jurors afterward, how they had no idea this is the way reality was. They've gotten their whole idea of the law on the courts from Law and Order or watching, court TV, which I guess isn't even court TV anymore. But so we need the media. The judiciary needs the media to be out there and explaining and educating. We need public officials to be informed about the judicial process. It was so clear during the Shivo case, either the lack of information or the misinformation that was coming from the politicians during that time, interfering with the judicial process inappropriately. And even those who knew better didn't say much and didn't speak up. And lawyers, and most of you are law students, I assume, and you need lawyers need to be outspoken advocates for the judiciary. If the judge is right on something, you need to be able to support the judge. A judge, most places, the canons of judicial ethics do not permit you to comment on a case. If I make a decision in a case, and a reporter calls me up and wants to know about it, I can't talk about it. If Judge Ito makes a decision in the OJ case, I can't talk about it. We're prohibited from making a comment on any pending case, even if it's not in front of us. So we can't do that. So when from time to time judges get attacked in the media, usually because we've made a decision that that is right on the law but wrong in public opinion, we need the lawyers to step up and say something. And most bar groups talk about it but don't do anything. If we're wrong, we need to, I think, that calls on lawyers to say so too. To say that this judge was wrong about something and to be able to hold the judiciary's feet to the fire. I think we really need you as the new next generation to come in and find new methods of judicial selection. There's ways of doing it. There've got to be, we're all hidebound, and once you get into it, you say, well, this is fine, I don't want to change my way of doing it. But maybe having public financing of judicial elections. So you're going to have a judicial election, everybody gets the same amount of money. It comes from a public fund, and so you don't have to worry about campaign contributions affecting judicial decision-making either in reality or in perception. Merit selection panels to where you have members of the public and members of the bar and others who select the judges rather than leaving it to the politicians or to the general public. What really needs to be done, and the ideas, I'm sure other ideas will come over the years to people who get into the system and try to think about it. And that's why this course is so good, because you get to think outside the box. You get to not just think as lawyers or just think as journalists, but to think, to understand where the other side is coming from and to understand different ways of looking at these matters and find some new ways. We're not so limited in our history that we can't find new and better ways, because obviously the way the American judiciary can continue to be the strong and important and effective branch of government that it hopefully has been and continue to be is by having the judges selected in a way that grants the most confidence in the system with the least concern about bias or undue influence, and with the understanding that competence, fairness, and intelligence is really the best qualifications the judge can have. I'll think around more than expected too much.
Thank you. We have until 4, so questions, please. I'm wondering if there's a mechanism that you haven't really mentioned here for judicial control, and I wonder if you think it would be consistent even with the exact system we have right now, with plenty of elections, record amounts of money washing into these elections, and that's recusal. Can we just have parties who are aware of this? Because you said, you treated it as if the litigants have this perception of bias, and then they're just sort of, well, I'm not going to listen to this court, or I'm not going to trust this court. Why don't we just encourage them to say, well, seek recusal of the judge or justice that you think is going to be biased?
That happens. I mean, I imagine every state has finance reports that that judges have to file. I know in Virginia, I have to let them know every stock that I or a member of my family owns. So if I had stock in Coca-Cola and a case involving Coca-Cola came before me, I certainly don't have enough stock to make any difference in it, that any ruling I make difference. But someone could look at that and say, okay, you should recuse yourself because you are a stockholder, your family is a stockholder. And that does happen. I mean, judges recuse themselves, I know personally, all the time. They just would look inappropriate. But one of the points that was made in the article from 2006 that was in the Times is that for the Ohio Supreme Court, the entire court would have to recuse itself. That's the problem. It's not, if it's a one-judge situation in a case-by-case basis, that's one thing. But you've got appellate courts where the entire court, and what do you do when you have a no-judge Supreme Court? So that, I think recusal's there, but, and I think it works on a case-by-case basis. And oftentimes litigants know to ask. Oftentimes they don't find out about the judge's contributions or anything else until after they've lost. That's part of the problem. Yes?
You said at one point there's no consideration of money. And in terms of the official, I guess you meant, in terms of that point, in terms of the official judicial evaluations.
That's correct.
And yet, in my mind, I'm not saying this is all connected, you know, as a justifiably strong response to what you're saying, but I got in my note this task. There exist ideological approaches that we seek to use to gain high moral ground. And what I'm getting at here is I really think that we're in an era where neuroscience and philosophy of cognition, and where I'm going here is that I really think that, and I heard something else recently about the biases that we have cognitively, like on C-SPAN just in the last week. And that's really where I'm going. That the basis that the public, or that a considerably normal person has in making multi-sectors, like 82 business sectors we're talking about, they can come to court, or family matters with very complex situations. I'm saying rationally making morally informed, appropriate decisions is, and for the court to bear forward and get their docket free of these cases, what I'm saying, I think is the court is enormously challenged to do justice.
I think there's no human being that doesn't walk around with his or her own biases. You're a product of where you were raised, your family, your background, your education. And what we tell judges is what we also tell jurors when they hear a case. You know, you've got to hear this case free of bias. That's why we do voir dire to try to find out, so the lawyers can find out, you know, do these people have anything in their backgrounds that might make them more or less sympathetic to one of the other sides. And judges have that too. But one of the things I think you know when you become a judge is you know you have to put that aside. You know, I'll take a sort of rude example. I don't like child molesters. I don't think anybody likes child molesters. If I have a case where someone is charged with being a child molester, I have to put that aside and listen to the evidence and make decisions and rule. And I think in some ways it's easier as a trial judge than it might be as an appellate judge. Because as a trial judge, you're constrained by the law. This is what the law says. This is what the law says that the evidence and the burden of proof has to be, and what's admissible and what's not admissible. So there are much greater layers of authority that govern you. When you get up to the appellate court, then you can, you know, sometimes say, well, the law is what we say the law is. But, you know, so I think that you have to understand, to be a good judge, you need to be able to take yourself with all of your background, your biases, your beliefs, and everything else, and be able to be fair and impartial, to treat the people in front of you with respect, and to apply the law fairly and the way it's supposed to be, regardless of how you might feel about what that particular individual did. And if you can't do that in that particular case, then that's a case where you recuse yourself. Then that's a case where you say, I can't be fair in this case. My feelings are such that I could not judge this case fairly. And you recuse yourself. And I've known judges to do that from time to time in cases. But you know, hopefully we're well trained enough and we're cognizant enough. And sometimes the cases in which you have the greatest feeling are the ones where you're the best judge, because you really work even harder to make sure that your rulings are absolutely, you know, without, because you know you've got that, you know inside of you that you've got that feeling about the individual, that you want to make sure that you don't let that feeling impact on your decisions in the case.
You mentioned in the Virginia system that the legislators at the time of reevaluation don't ask questions about politics and positions that you're going to take. And I guess my question is, in an increasingly politicized society, what's to stop them from doing that? What's to stop the Virginia system from moving to look exactly like the United States Supreme Court confirmation hearings?
Nothing. It just hasn't happened. There's nothing to stop it. And there are reports from time to time of questions that have come up by individual legislators. One, I think, and a lot of these are just stories you hear at judicial conferences, where one legislator asked someone who was seeking a judgment, well, what have you done for the party? Well, that has nothing to do with my head. Others who have said, I think one legislator last year refer to an applicant for a judgeship to her face. She was sitting there meeting with him, and this was reported in the papers. He called her a feminazi. He said he didn't like feminazis, and he did not support her for the position. And yes, is there anything to prevent it? No, except for what has always been regarded as the genteel Jeffersonian practice of we don't do it that way in Virginia. But it does happen. There was a situation several years ago where there was a vacancy in the circuit court in Alexandria. And there was a Democratic governor, Mark Warner, and what happens is if the General Assembly isn't in session, a judicial vacancy occurs. And the General Assembly is only in session with a part-time legislature. So they're in session only for either 45 or 60 days in opposite years. So you're talking about January to March. So if a vacancy occurs in June, as it did in this particular time, it's a governor's appointment. And then the legislature has to elect the person the following year. Otherwise, they lose the job. So there was an African-American juvenile court judge who was very qualified. He was a Vietnam veteran. He had been a judge for a long time. He was a native of Alexandria. And the local delegation supported him. The governor said he wanted to appoint him. But the members of the House of Delegates said, we don't think so. We want our candidate. There were no elected Republicans in Alexandria, just like in Arlington. So they said they wanted their candidate. So it basically became a stalemate. The judge could not afford to give up his position on the juvenile court for the chance of staying on circuit court, because if he didn't get reelected the following year, he'd be out of a job. And so basically the following year, the governor ultimately appointed someone who said basically, he didn't appoint anyone in the first year. Then the next year, the same thing happened. The General Assembly deadlocked. The Senate went with the juvenile court judge. The House went with somebody else, and so they didn't like anyone. So then the governor appointed a lawyer who basically said, "I'll take it, and if I don't get reelected, I'll go back to practicing law." So it wasn't a big deal. And then ultimately they agreed on her for other probably political reasons, given the fact that some of the people running for statewide office and not wanting to knock a woman off the bench. But in any event, there are issues that come up. I'm not saying that politics doesn't play a part from time to time. We don't know what's going to happen this year. This is the first year in a long time we've got you've got a governor of one party, a House of that same party, and the Senate of that same party, and a House of another party. So it's going to be interesting to see what happens. But those are fights yet to be had. And luckily, I'm not in that right now. But yeah, there's issues there, and everyone there was wide suspicion when the Republicans took over the General Assembly that all the judges who were elected during the Democratic era would all be thrown off at their next re-election, and that didn't happen. And lots of people worry about things, but that didn't happen. There's no in that overt political area that hasn't happened yet. There has to be more people coming on than people staying on.
Judge Alper, I was wondering, we touched on it a little bit with regards to qualifications, because I know we get kind of caught up with political aspect of judges being elected or selected by the legislature. But do you find that the legislative, in terms of the pure qualifications, given the nature of being a judge and sort of needing to be qualified to write the opinions and actually handle managing a court, do you feel that popular elections are less or more able to bring a qualified candidate to the bench versus a legislative election where there's kind of a perception like, you figure the legislators they're through a confirmation process, they're vetting a candidate, they're being more thorough about their ability to be a good judge. Is it about even, or do you feel that it's definitely not? Is there the bigger risk of being a less qualified popularly elected?
In my opinion, there's a greater risk of a less qualified person being popularly elected for two reasons. Number one, I think the idea of running for election in that kind of a situation, I think that turns a lot of people off. A lot of people who might otherwise be good qualified judges might just not want to go through that process and be trying and raising the money and all that. So I think that's one. Secondly, I think the scrutiny that's given by the members of the General Assembly, the input they get from the bar, from others, from some local delegations have citizens committees that they refer everybody to ahead of time. Every local bar has a judicial evaluation committee, and they do screening of the applicants for judgeships, and they write long reports, and the bar members vote on whether the people are qualified or highly qualified. So and then the members of the General Assembly themselves sit down and talk with you, both the local delegation and the courts committees, and they'll ask you substantive questions. I remember being asked questions when I went from the juvenile court to the circuit court, and there were some substantive questions, not about how would I rule in a particular case, but they wanted to know how I thought about things and what and I think they didn't really want to know the answer. My opinion was that there wasn't any right or wrong answer. They wanted to hear how I communicated. They wanted to hear how I approached things. They wanted to hear, they just wanted to see how I thought. And I think that to me is better than, if I'm sitting there watching a 1-minute commercial about a guy who wants to be a judge. I think to me, it's just a much more substantive method. And now with these judicial performance evaluations, they're going to have even more information.
At lunch, you were telling a story about some people being elected. You said you have to want to be a judge to be a good judge. And if you get there, you have to want to be in court. And if you don't want to be in court, you're going to be rude, you're not going to get your docket done, you might fall asleep. You could be immensely qualified, but unless you really want to be a judge, you're not going to be a good one. So it seems to matter really not how people get on the bench, but what they do on the bench. So things you're talking about, last week we had someone talking about these judicial performance evaluations. And I was wondering, how seriously does the Virginia legislature look into performance evaluations? I mean, how often are people getting not reelected, or is the election automatic?
Well, no. First of all, our judicial performance evaluation is very new. In fact, I haven't been evaluated yet because of the way they just started it the year that I was up for re-election in 2006. And the rule was that they were going to let you have one evaluation that you could see. So it's supposed to be a learning tool for the judge, too. So if people are saying you're doing this or that, you can fix it. And then the next one would go to the General Assembly. So it's brand new. And I think it's a great tool because it does get input from lots of people. And you know what? You're going to get some people, especially when you deal with litigants and lawyers, some of them are going to say you're absolutely great, and and then at one end, there's some going to say you were absolutely terrible, and the worst thing in the world. And if you sort of take off the highs and the lows, the middle is probably the most accurate picture. But over the years, there have been a number of instances where judges in Virginia have not been reelected. And I can think of a number, and there's one right now who's struggling with one based upon rulings and some things that he made, and there's some criticism about his demeanor in court and the way he treats criminal defendants. I don't know what's going to happen with him. He's happens to be a friend of mine. I like him. I hope he gets through. But the re-election is not automatic. There were a number of judges a few years ago who were elected at their first re-election. These were lower court judges. Two of them were told, "You've got some demeanor issues. We've had a lot of complaints." And they say, "No problem. I'll straighten out and I'll get better." And they come up 6 years later, same complaint, and they weren't reelected. So it's not pro forma, and it shouldn't be pro forma. And I don't think you'd see any judge in Virginia who would tell you that it should be. There's also judges who've gotten into disciplinary issues, and there's a disciplinary arm, as I said, of the Virginia Supreme Court, the Judicial Independence Commission. And if they've got a file on you, if somebody's filed a complaint lots of people file a complaint. I didn't win my case, I'm filing a complaint against the judge. But if there's someone's filed a complaint against you and it's had some basis and they've had to investigate and deal with it, General Assembly's going to know about it. And there were a number of judges this year who, when faced with that coming out, because the proceedings in the Judicial Review Commission are usually private, just didn't run again. They resigned or retired. So there are, I think, fairly good controls. Let me contrast that with something. Now, I don't know how many of you heard about this story, but in suburban Maryland a couple of years ago, there was a judge on one of the lower courts who had granted a protective order to a woman who was afraid said her husband was threatening her. And he granted the preliminary protective order, and it came in for a full hearing, and the husband was there. And the judge denied the protective order. And not only denied it, but apparently made some comments from the bench that were reported, including, you don't need her, you go find another woman. Women are like buses, another one will come along, shortly. And he made some really demeaning comments to the woman about how she was overreacting and all that, and was really rude and arrogant to her. 2 weeks later, the husband got her outside of her workplace, doused her in gasoline and set her on fire. And she suffered horrible, disfiguring, debilitating injuries. She survived, but I've seen her on TV, and it's really a disaster. But this judge came in for great, and he had been elected and re-elected. He was an old pal from Maryland, and they found out other things like, when they started looking into him, the post got after him. That's usually a good thing to do. They found out that he had gotten, had car accidents and speeding tickets, and told the cops, I'm a judge, you can't give me a ticket and all this stuff. And I believe he's been moved from the bench now. Either that or they're just not letting him hear any cases. But there are ways, I'll be the first one to tell you. There are judges out there who shouldn't be judges because they abuse their power. And there are judges out there who shouldn't be judges because they just don't like doing what they're doing and don't want to be there. None of you as lawyers are going to want to walk into a courtroom with a judge who doesn't want to hear your case. And they make it very clear to you. And so those are all temperament issues. And I think temperament and your willingness to sit there and listen and be patient. Because if you have a person, say they've got a traffic accident, or they've got a traffic ticket in the road court, that's the most important case in the world to them. It may not be the biggest case I have, it might not be the most challenging, but that's their only contact with the legal system. And if they get short shrift, or if the judge makes fun of them or demeans them, how are they going to walk out and think that the system is any good? And that's the judge's responsibility. That's not the general public. That's our responsibility to make sure that doesn't happen. And sometimes it happens with where you have to go hard on a colleague, and you have to, or the General Assembly has to take a judge off the bench. But it happens, and it's happened. It happened in cases that go all the way to the Supreme Court of Virginia, where the judge doesn't want to agree with the discipline. There was one judge in traffic court down in Tidewater who had been a judge for a very long time. And he kept telling defendants, I have a special meter here, and I can tell when you're lying. The light goes on at my bench. And he was telling people for a year. He was just doing stuff like that. And they ultimately, the commission got after him for a number of things he had done. Took him to the bench. So hopefully we're, just like the bar is self-regulating in terms of attorney discipline, judges should be self-regulating. Bad judges shouldn't even get to the issue of being reelected or being appointed by the General Assembly. We should make sure that they're taken off before that.
Both in your bench press article and then when you were speaking, you talked about the legitimacy being tied to the issue of public perception. And I was wondering if you could comment on whether you think the public perception of the judiciary is tied to the public perception of the lawyer as a profession. Do you think that people see judges as lawyers with more power, or do you think they see them as somebody else?
No, it's funny. It's funny because I always still think of myself as a lawyer, even though I've been a judge for 17 years. But when you talk to members of the public, specifically when you talk to jurors, we get a lot of people when we talk to jurors. They really look up to the judge. The judge. That's why you have to be careful. I always tell the jurors in my opening comments to them, no statement or ruling or remark or gesture which I may make is intended to indicate my opinion of the faculty. So, I'm careful. Sometimes I don't even want to grimace. I hear some evidence and you want to roll your eyes, and you can't do that because that jury, they're not looking at the witness, they're looking at me. And they may not like the lawyers, but they still have, from what I found of the jury, they do like the judge. So they don't confuse you with a recovering lawyer.
It's sort of a general question. You've spoken and written a lot about just how important it is to maintain public confidence in the judiciary. And I'm wondering how we can have a system that can reconcile what I think is the competing ideas of public confidence and the idea that the public thinks the judiciary is responsive to them, and the counter-majoritarian role that courts sometimes have to play in validating, for instance, acts of the legislature that might be extremely popular but would be unconstitutional, and the judge would have to follow the law and say, I'm going to have to invalidate the act of the legislature and incur public wrath. So how can we have a system where a judge is free to do that and not lose public confidence in the judiciary?
Lifetime appointments. That's why federal judges, that's exactly the reason why federal judges had lifetime appointments, so that they could act without fear of recrimination or fear of losing, their job or anything else. And I think that's the answer. You don't have to worry about it. You can make that decision. Although, there's even situations where federal judges have reacted to public outcry. Remember the case years ago? There was a judge in the Bronx, I think it was. I think his name was Judge Baer. He was a federal judge appointed by Clinton, and he ruled on a motion to suppress, and it was tons of drugs in the trunk of a car. And for some reason, I don't know how it got into the media, but the media caught hold of this decision that he had made in a case that was otherwise nothing, out of the ordinary. It was a big drug case. And there was such outcry, and of course, then the interest groups caught hold of it. I don't know that it was the public generally. I don't know that the citizen on the street in the Bronx or New York really cared, but some of the interest groups, and whether they were anti-Clinton interest groups or, I don't know what the interest, but they got a hold of it. And then you start talking about it, it gets talked on talk media, it gets on the internet. And there was such a cry, and they were talking about, people were saying we ought to get rid of this judge, the generalist, the Congress ought to impeach him or whatever else. And I was so shocked, because there have been plenty of federal judges who have made horribly unpopular decisions. I'll give you an example in a minute. But this judge went back in and changed his opinion. Went back in and changed it, which to me was unbelievable. But you talk about some of the great things in our country would not have happened but for the willingness of federal judges to do what was right. And putting aside something as major as Brown versus Board of Education, in Richmond, Virginia, there was a judge named Judge Merritt, a federal judge who was just an incredible guy. He just passed away recently. But he had some of the school desegregation cases in Richmond during the 1960s. He was regularly threatened. His dog was killed. They tried to firebomb his house. I mean, he went through horrible personal, but he stuck to his decisions. He ruled on the integration of the schools in the Richmond area. And, would he have been able to do that if he had to run for election? Would an elected judge? The elected city council couldn't do it. It took a federal judge with a lifetime appointment and with a sense of his convictions and knowing what was right to do what had to be done. And so the answer really is to have an appointment that isn't dependent upon the public for something like that.
I don't know if you heard about the incident last week involving Jeffrey Toobin in the New Yorker writing about the case in Atlanta where Brian Nichols is charged with killing 4 people in a courthouse escape. The judge in the case spoke to Jeffrey Toobin, who was in Atlanta working on the story for the New Yorker, and uttered a phrase something like, "Everybody knows he did." So of course that was in the story. Not in the lead, not in the top of the story, but it was in the story. And he got bounced. Okay, so that
I think he bounced himself.
Yeah, yes, he bounced himself before he got bounced. But, I mean, everybody would agree that that's not what judges ought to be talking about. But when you said that the system can be carried out and maybe accept the rules as they are without questioning them, is there any doubt in your head about the rule about judges talking about cases to reporters? What's the difference between committing your opinion to writing and explaining your opinion?
I think you can talk about it after you've made it. There's no prohibition once the case is over. It's a pending case. That's the issue. And obviously you don't want to be, just like we're not supposed to talk about a pending case to, I'm not supposed to call the lawyer unless it's an official, part of the record. To talk to the lawyers about a case or talk to a bar group. It's no different than that. Talking to the media is no different than my standing in front of a bar group and saying, I'm hearing this case right now and it's really interesting, I've got to tell you all about it. You're just not supposed to do it. And part of the reason is because you're supposed to make the decision on your own without input from anyone else. The same reason we tell jurors when they're in the middle of the trial, when you go home tonight, don't talk about the case to your wife or your boyfriend or your girlfriend or anyone else. Don't talk about it to anyone until you're in the jury room and you're deliberating, so you don't get input. If you talk about it, you say, this is a great case, and it involves a, auto accident on Lee Highway and Glebe Road, and next thing, I've been by that, and I saw, what about, and all of a sudden this person who's not on the jury is giving you ideas. So that's one of the reasons why you're not supposed to be discussing it with anybody, much less the media. The media just winds up, judges have such an innate distrust of the media at this point, because many judges have been burned by the media, so they sort of don't trust it. And having come from a practice where I represented the media on numerous occasions, and and really enjoyed it. It was one of the main First Amendment cases in the Supreme Court of Virginia. It was one of my cases, and I loved it. At the same time, I understand now why judges are reticent to talk to the media, because the whole thing doesn't get out there. You say this long, lucid, coherent sentence, and they find the one little soundbite that doesn't make you look good.
Well, accepting all that is true, which I basically do, haven't you seen judges that do themselves no favors in not explaining their reasoning in a written opinion, not granting access to records or hearings that would otherwise explain what is going on? I mean, our judges, can't they take some measures to enable the media to do a better job?
Absolutely. Absolutely. It's not just enabling the media. Explaining your decision, I think, is essential for the litigants. Put the media aside. I've always strongly believed that most of my decisions are not made in writing. You're a trial judge. I make my decisions right from the bench. But I think it's important. As a lawyer, if I was representing a client, you know, if I won or if I lost, I wanted to know why. You know, I wasn't just, okay, I rule for the plaintiff. So I've always felt very strongly in all the years I've been on the bench that I explain my reasoning for how I reach my decision. Because if it does nothing else, it makes sure the litigants know that they've been heard. To me, it brings greater acceptance of my decision. If I'm a litigant sitting out there and I have been put on this great case, and the judge just says, okay, you lose. Why? Well, maybe the judge wasn't listening. But if the judge goes through the evidence and recites what persuaded him or her and says, well, here's why I did what I did, I may still disagree, I may still appeal, but at the same time I'm going to understand and I'm going to know that that judge listened to me. So again, it's my personality is such, until I talk a lot, I'll explain my decisions. And when I write a written opinion, I'll write, if it's something I need to write, I'll write it out. So I agree with you, and I think that's important. And closing courtrooms is a real bugaboo with me, because I know that, from time to time people want to close courtrooms, and it's got to be an enormous reason to ever close a courtroom, because I don't believe in it. I was delighted when I was a juvenile court judge. They passed the law to make juvenile courts open in juvenile criminal cases if the juvenile was 14 or over and was charged with a felony. And I thought that was a good thing. I thought I don't like closed courtroom and locked doors and things like that. But the problem is the courtrooms are open, but the media doesn't come. I had a major case involving the issue of the affordable housing ordinance in Arlington County, what the county board had done and whether they had the authority, with the developer suing the county board. This was a major issue in our community, because the real estate prices were going up so high. There was no place for people like teachers and firemen and policemen and people who made $50,000, $60,000, $70,000 to live. And the county board rightly, and this is another one of those situations, the county board rightly wanted to change that and to do something to push the developers to give more for affordable housing. But Virginia is what they call a Dillon rule state, and the only authority the local locality has is what the state gives it. If the state doesn't say you can do it this way, you can't do it. And so the case turned on whether or not what Arlington had done qualified under the Dillon rule. And the issue is, I thought the policy, in my own mind, everyone agreed. Everybody, all sides agreed the policy was a good idea. But this wasn't the right way to do it. And ultimately, that's what I had to say. But where was the media? The media wasn't there. The Washington Post wasn't there. It was a major issue. And they picked up on it after the local paper, got the decision. So, and it would have been nice to see some kind of interplay to know that to have the public even know that issue was pending in front of me, because there were a lot of people in Arlington that were interested in it.
We have time for one last question.
Quick question. Judge, you mentioned that your main critique of the election method was the money more so than the politics. Now, having said that, couldn't that just be fixed by campaign finance laws like they do in presidential elections? Without having to sort of resort to the Virginia system, which I think has a distrust of the public in their capacity to make an informed decision.
Yeah, I think you could do public financing of judicial elections where everybody got the same amount, or you could do some kind of, something similar to what they do in the presidential elections in terms of campaign finance. But my understanding is in the presidential system, they can opt out. The candidates don't have to go under that. They can choose not to take those funds and raise as much as they want. So it would be different if you just said, fine, we're just going to have all public finance and you can't raise your own money. Here's how much money you get for your campaign. But I have a feeling the problem with that would be, I have a feeling someone would say it would be a violation of the First Amendment. There's that case that came out of, I think it was Minnesota a few years ago, Republican Party versus White, where they challenged, there were rules that judges couldn't talk about certain things in the judicial ethics rules. And judges there said, well, how can we campaign and run for re-election if we can't talk about this? So they sued, I'm not sure who exactly brought the suit, but the suit ultimately ended up at the U.S. Supreme Court. And the U.S. Supreme Court struck down the restrictions on what the judges could talk about because they said it violated their First Amendment rights. So similarly, I would imagine if there was some sort of a rule that said you could only spend X amount of money, or you could only raise X dollars for your campaign, if you extrapolate the Republican Party versus White, that might wind up being unconstitutional. I don't know. But I agree. As I said when I included, if you had some sort of public financing or some method of financing that didn't depend on individual contributions or limited contributions, then yes, that would take a lot of the problem out. It wouldn't solve the issue of public education and having an informed electorate, but it would solve the problem of the appearance that the decisions go where the money comes from.
Thank you, Judge Alper. This concludes the public section of our lecture. The Law, Politics, and Media course will reconvene at 4:15. But please join me in thank you.